Great. Okay. All right. Welcome everybody to the meeting of the Early Learning Council's Ad Hoc Committee on the Child Care Safety Portal. Thank you all for being here today. And as usual, I think we'll start by introducing ourselves, and if you would please say your affiliation, that the hat you're wearing when you're on this committee. I'm Sue Miller. I'm chairing this committee, and I chair the Early Learning Council.
Eva Ripito, AFSCME representative. I work with licensed in-home child care providers.
Thank you.
I'm Adam Bergen. I'm the new unit manager for DHS's Otis unit to see over the educational investigations.
Awesome. Welcome, Adam.
Thank you.
I'm Stephanie Fortner. I'm a parent of an almost 2-year-old who goes to a facility daycare in Clackamas.
Veronica Ochoa, and I have a 3-year-old in a in-home licensed child care.
My name is Jay Messenger. I'm the Legal and Enforcement Director for the Office of Child Care.
My name is Mary McCord. I am a legal compliance specialist for the Office of Child Care.
Welcome, Mary. Thanks for being here today. I understand you're filling in.
I am filling in.
Thank you. We appreciate that. While we're here, Angela.
Sure. I'm Angela Rodriguez. I'm the Quality Assurance Manager for the Early Learning Division, and I'm the lead staff for the committee.
Thank you for your work to make these meetings work.
Jerry Moore, the Chief of Police in Salem.
I'm Bobby Weber. I'm a retired faculty research associate at OSU. I do early childhood research, and was formerly, when I was put on this, it was to provide a link with the Early Learning Council, but I'm not part of the new council.
But Bobby was a founding member of the original Early Learning Council.
Right.
It was
2011.
A long time. Thank you, Bobby.
And hi, I'm Dawn Taylor, and I'm the Child Care Director at the Early Learning Division.
My name is Renee Holmes, and I am a 24-hour provider in North Portland.
Heidi McGowan, facilitator for our committee.
Thank you, Heidi. And as always,
Kristen Kiefer with
thank you.
Jason Stone with the Early Learning Division. Or Cordell Early Learning Division.
Awesome. Thank you, everybody. Oh, and on the phone, thank you.
This is Shannon, Program Director of Child Care Resource and Referral, or a program of Community Action.
Great. In Marion County. Okay.
Yes, Marion, Polk, and Yamhill.
Marion, Polk, Yamhill. Thanks, Shannon. And Sarah.
Hi, I'm Kara Tachikawa. I'm the Program Director at Mountain Star Family Relief Nursery in Bend, Oregon.
Thank you for being on the phone. And is someone else smart?
That's just us.
Oh, that's our picture.
Yeah.
Oh, that's smart. Got it. Okay, we've already met you. Thank you. Okay, we will get started then with our agenda and ask Heidi to talk about our progress to date and then agenda.
All right, so this is our 5th meeting. Angela reminded me when we were setting up. Good work, and I just want you to refer you to page 5 in your packet. You'll see a really brief summary of the progress and the recommendations that you have come to each month. I'm not going to walk through them. I walked through them last time, but they're really short and brief summaries. Thank you, Angela and Jay. This is so helpful to have and really demonstrates the work that you all have done. If you'll take a quick look at page 7, just want to refer you back to where we came to in August. In August, our last meeting, we talked about what information about a child fatality should be made available. And we had some questions around that. And you'll see a little bit of a notation here, and I just want to highlight that there was general agreement from you all that there should be basic factual information of a child fatality known within 48 hours on the child care portal on the website. And so I just wanted to highlight that in sum. That was the recommendation. There were, Chief Moore had offered to talk to some of your colleagues and get a little information about if there would ever be a concern going forward. So I just want to, maybe you can share briefly what you learned and as follow-up.
Well, Kevin also was able to follow up with DA, or tried, and I can go on, but I think I didn't have any feedback on the basic information that we talked about last time. If it was when, where, who, place, it was just basic. It's the same thing that go out in a press release if we did one, and a lot of people didn't get back to me, which means it didn't matter to them. A lot of people did say, we're fine with that. The only thing I would say is, most of them said, there may be that one time when we are concerned and we're going to have to figure out something to do there. But for the most part, I don't think they had any issues. Now, you have to remember, we are not, we'll investigate it, but if there's a death, it's not ours, it's the DA's and it's the medical examiners. So they obviously have a big piece of this pie.
All right. Welcome, Mr. District Attorney. Will you just introduce yourself, Kevin, since we've already done that?
Sure, I'm sorry I'm late.
No problem.
My excuse was there was an accident on 217, but I suppose that excuse holds true most days of the week these days. So, I'm the DA in Washington County. My name is Kevin Barton, and ditto to those comments. So I wasn't at the last meeting I had, someone here in my place, but was able to forward along all the DAs in the state. Most did not respond. Those that did gave the same feedback.
Okay, great. Thank you both for getting those surveys out so that we could collect information from the fields that you both work in. So that will certainly help in our discussion.
Great, excellent. Okay, so thanks for that follow-up, and this recommendation will move forward to the Learning Council. Okay, so let's go ahead and move forward into our topic, our discussion item today. If you can turn to page, just on the back side of your agenda, is what we're going to be covering. And I think we're going to be talking about incidences of substantiated child abuse. And so, Jay, I'm going to turn it over to you to maybe provide a background information, and then we'll break up into groups as we've been doing.
Sure. So I'm going to go through the background information in three parts. First, just an introduction to the question, then a brief overview of the background materials we provided with a particular focus on the comparison chart, which shows what DHS does versus what the Early Learning Division Office of Child Care does in situations in child care where there are allegations of child abuse and neglect. And then finally, return back to the question page to discuss our recommendation that we've put forth as a staff recommendation. So the question for this month is, what information regarding incidences of substantiated child abuse in regulated child care settings should be made available on ELD's website? And just for clarity, when we say substantiated child abuse, it can only, that is sort of the CCDF term. In this state, we use the term founded child abuse instances. So you can sort of say substantiated and founded are the same thing. And first thing to point out in this topic, just to sort of set the topic, is these are results of DHS's investigations. And we're going to hear, that's both in the child welfare area and now in the OTIS area. We have a representative from OTIS here today, of the Office of Training, Investigations, and Safety. And I expect we'll have on the line at some point a representative from child welfare to also add their input. And so currently, we're in a transition phase at DHS, or they're in the transition phase at DHS. Currently, the child welfare area does investigations of allegations of child abuse in child care facilities. Sometime in 2020, that function is going to be turned over to Otis. And I'm sure Adam would be happy to talk about that if we have questions. And so another point to point out in general is that the Office of Child Care does not investigate child abuse per se. We don't have rules against child abuse. What we do investigate is the facts surrounding the allegations of child abuse. So for example, hitting, that could be physical abuse in the child abuse realm. That could be a prohibited punishment in our realm, because we are a regulatory agency. We investigate health and safety violations. We don't come to determinations of whether there was child abuse or not. That would be DHS. So that's just important to keep in mind, that when we talk about the information that we post on the this portal, substantiated child abuse, that is actually the results of DHS's assessments or investigations, not the results of our investigations. So we provided you in the background materials several things. First of all, this comparison chart that I'm going to briefly go through. We've also provided, just because I assume many of you have heard of child welfare, but perhaps fewer have heard about Otis, the Office of Training, Investigations, and Safety. And so we've included flyers from Otis that talk about what they do. The child care setting aspect is just one aspect of what they do. And we also talked about their hearing process as well in the provided materials. And so now moving first to this comparison chart, we've broken it down into sort of several categories to try and help understand the relationship between the Office of Child Care Early Learning Division and DHS's teams when dealing with allegations of child abuse in a child care setting. So the first item is role. And so as I mentioned, we conduct regulatory health and safety investigations, looking at violations of our rules, administrative rules. We don't look at child abuse. But we could look at both the facility and the individual. So for example, to take that very simplistic example, if a teacher punched a child, we would look at both the facility for a potential regulatory violation, and we look at the individual to determine if they're still suitable or not to remain in our central background registry, which is a prerequisite for them to being employed at the child care center. Child protective, child welfare, and Otis will look at child abuse. And so we'll talk a little bit later about investigations that we do together, tandem investigations. It's a new, I think we've referenced them here before in these meetings. It's a new process where we work with DHS to go in and investigate allegations of child abuse. Well, DHS investigates child abuse. We look at the potential health and safety violations arising from those facts. So the roles. Decision making. We've talked, going on to the next page of the chart, we've talked in previous meetings about our standards for finding valid, invalid, unable to substantiate. We had extensive discussions in June about how far back we want those posted. We've also talked about how we can also have legal, in addition to these findings, we can also have legal actions. And so that is talking about the facilities. Also, we would look, as I mentioned, whether someone is involved in child abuse. That's something we look at to determine whether it's included in our analysis of whether they're suitable to remain in our central background registry. Now, DHS, both child welfare and the Office of Training, Investigations, and Safety, uses different standards. They use founded, they use unfounded, and unable to determine. And they also have a different evidentiary standard, reasonable cause. We are, over in the OCC side, are dealing with preponderance of the evidence. And so, Adam, is there anything you want to add to that?
No, I mean, as far as the reasonable cause piece of it, or?
Yeah.
I mean, it's essentially we're saying whether, it's all the same, right, as far as the language, whether it's founded, unfounded, unable to determine, or unable to substantiate. We're essentially saying the same thing when we look into it. We're looking at would a reasonable person believe this occurred, it didn't occur, or is there not a way to be able to determine whether or not it incurred, i.e., it would be unable to determine in a circumstance where we had we weren't able to get a hold of our victim for interview, or we weren't able to get a hold of the alleged person for interview. Situations like that where we can't go one way or another, but we try really hard in our office, whether it's on our adult team or juvenile team, we try really hard to come to a finding.
Thank you.
So a quick question, Adam, is Otis new?
Otis isn't new. It used to be called Awabi, and so it just changed name. They've been in an identity crisis for a while, so they've changed names a few times, and they felt that I can't remember what Awabi stood for.
The Office of Adult Abuse Prevention and Investigation.
Same office, they just changed the name here, so it's the same group in the same building. But they've been around for quite a long time. Before I was with Otis, I was with the Oregon Youth Authority doing investigations, and I worked with the OWAPI team to. Go ahead.
No, it goes to the.
Oh, okay. I worked with the OWAPI team for quite a while. I'm not sure exactly how long in history they've been in place, but. Okay.
I've just never heard of Otis. So
Okay.
nice to have you here.
So, was there statute, or was there legislation that gave you regulatory oversight of childcare?
Yeah.
Because when I ask somebody about, because I know that, was it this last session?
Are we talking about the educational piece? So the educational piece came out of Senate Bill 155.
Okay. Because when I ask somebody, does this have anything to do with childcare? I was told, no. Seeing the list, it's not child.
So if we're talking about the educational piece that they just came out with, that's that Senate bill. We've had regulatory oversight over adult PD, mental health, and the juvenile components. Okay. Yeah.
Okay. I don't need to drill down into Otis. I just never heard of it. So thank you. Okay, Jay.
So the next row is due process, and the reason that that's in there, it's the process we follow in reviewing decisions, both our Office of Child Care, which we've talked about in previous meetings, and also DHS, Otis, and Child Welfare. And the reason that's in there is that in our proposal, we are saying that we're going to be posting final orders. So the substantiated child abuse that we're recommending posting is the result of a final order, and there's a process to get to that final order. So I've included that process here just so folks, if they wanted to, could understand. But you can see both with Otis and with Child Welfare, without getting into details, there's statutory process they follow, there's timeline, so it takes, just like investigations take time, it takes time to get to a final order. So, you're going in to investigate a facility for child abuse, it's going to take time to get that final order, which would then, per our recommendation, the guts of, or the basics of that would end up on the Child Care Safety Portal. So that's what the due process is about. Child abuse types. To me, when I first started working this job, it was, I've been exposed to child abuse law and whatnot, but I didn't understand the broad variety of various child abuse types. So we put them in here in a list. We've also today, Angela sent out a nice one-pager that's put out by DHS, which lists the various types of child abuse and provides examples. I think that's, if you're sort of uncertain as to what a particular type means, this is a great sort of one-page document to get you familiar with the different types that might happen in an investigation or assessment. And just once again, on the OCC side, we don't have a standard for child abuse because we don't investigate that per se. And then the next row is the investigation results. So what happens at the end of the investigation? What comes out of that? On the OCC side, if we're looking at individuals, and they're found not to be suitable to be in the CBR, we go through a contested case process to try to remove them from the central background registry. If they're removed, we don't post that any place, but we do let a provider know that if a person is associated with a facility, that person is no longer enrolled in the central background registry. And if they're no longer enrolled in the central background registry, they're not eligible to be employed at a child care facility. As we've talked about in previous meetings, for our findings, of course, it's portal, right? Our findings go up on the portal, and we've talked about that in depth. For child welfare and Otis, Adam can feel free to comment if he wants. These dispositions, they're typically against individuals not facilities. There are some cases where there are abuse, findings against facilities, but in the case of an individual, certain people are notified, and I've listed them there, but it's not like it's posted anyplace. Okay. And then my final sort of row is about DHS and OCC coordination. We started off, and it's been mentioned here before, we started off in 2018 with a tandem pilot program between OCC and child welfare, and now Otis is involved in the planning, and there's a goal to roll that out statewide in 2020. But I'm going to turn it over to my colleague Mary to just give a little description about what that tandem investigation process is, what that means.
All right, so OCC will typically receive a cross report that's coming from DHS by way of usually a phone call or a fax or an email notifying us of this open assessment that's possibly going to occur or has occurred at a child care facility. And so they will reach out to us and let us know that this is happening. Then the person who's coordinated, typically a lead person, or other staff that are in a compliance unit, will coordinate with the investigative specialist, who is the one that's going to join as a tandem team with the CPS worker. And so we exchange numbers, email, whatever it is, to make that happen. Typically, they want it to occur that same day if the response time is warranting that. If it's a little longer, then it doesn't happen that very same day. So we make that connection so that the IS and the CPS worker can go make their visit. We also do a little bit of prep work before they do it. We send chronologies to CPS so that they can have historical information on the facilities, so that they have everything they need before they go. So they've coordinated this, they make contact at the facility, and they start doing this investigation together. And that means they're interviewing the provider / director, whether it's in a home or a facility, and they're getting to hear the same exact information that the CPS worker is hearing prior to, or I guess in still some other counties, they still do it this way. We were having to wait for the CPS worker to complete their investigation before we could initiate any contact, so that we wouldn't interfere in their investigation. So now we're actually hearing the same stuff, participating in some of the interviews that occur with collaterals, whether it's the children, the teachers, the parents. So they coordinate all of that together. Typically a few days later, we get an update, unless it's something really concerning and we need to know now. We'll have another staff group talk over the phone about what has been found so far and where they're at with it, whether there's any concerns at the moment, and so those get addressed then. Once that happens, they either continue, and pretty soon it's getting wrapped up. When we've had that phone call, at that point we're deciding at Office of Child Care whether or not that's going to affect somebody's license, if there's big concerns like that. One of the advantages that I've seen about that is that we do get to have the information sooner, and we don't have to wait, which is nice. It helps us make the assessment that we need to make without having to wait. Right. Yeah. That's just a nutshell.
What happens if OCC and child welfare disagree on a finding?
Well, OCC will make a separate finding than theirs. I've seen that happen before. They don't always agree on the same thing because they have a different scope.
Yeah, just to kind of add to that, because when we go out, we kind of are intentionally calling them tandems, because we have our regulatory framework and our rules that we're determining if there's a regulatory violation against our child care facility rules, and then they're doing an assessment based on if abuse occurred or not, if it's substantiated. So yeah, they're really in different lanes, but you're doing it together, so you're getting that, our staff are getting that firsthand information.
So can you talk about, so it could be, I don't have the words right, founded, no, what's the right? Yeah, founded child abuse, it's hard to believe, but invalid facility violation. That's hard to believe.
It would be hard to believe. It would
Okay.
most likely be, like in that scenario, there might be a supervision issue, corporal punishment, we have a rule about that. So whatever kind of that within our regulatory framework would most likely, if it was founded for abuse, there would be some regulatory issue
Okay,
that
so
would be addressed.
if it's unfounded child abuse, you still could, this would probably be more likely, you could still have a valid finding about breaking an office childcare rule.
Yeah.
Yes.
That's probably more common
Yeah,
than the
an
flip,
example
right?
would be, let's say they were assessing lack of supervision. So if children were left unsupervised, but they weren't hurt, maybe DHS might say that's okay because there wasn't a true danger at that moment. But Office of Child Care will say there was nobody watching them. So that could be valid. Yeah. So there's two different scopes.
Okay, question, Eva.
Do the tandem investigators ever do return visits on their own, or should they always be together? Like, once they start the interview process, do they always go back out together?
I think they typically do them together. I don't know if they can always join though. So it might be an instance where they make contact on their own.
And I assume because there've been 5 pilot tandems, they must have been successful if you're now rolling them out statewide.
Yeah, I would say some initial data that we've had is we're able to take an action much quicker. We actually are doing surveys with both the child welfare and our staff, as well as the provider who is involved in this. And the survey results are that both the child welfare workers and our licensing specialists really appreciate having 2 sets of eyes and 2 sets of ears as they're hearing through the interview process, that's a support that's helpful. Additionally, and you can imagine for a provider, this is a stressful time, but even providers are reporting that they are appreciating only having to tell their story once, instead of having to come back maybe a month later when we go out to retell it. So yeah, it has definitely shown to be a good practice, yeah.
Great.
A couple
Great,
questions.
yeah.
I'm not sure who to direct these to, so I'll throw the question out and whoever knows the answer maybe. So I maybe starting with the tandem issues. So typically when DHS is investigating an abuse concern, they'll work in tandem with the law enforcement agency if there's a crime. So the worker will go out with the patrol officer for the initial conversation. And what I hear you saying is that the goal here is to have the DHS worker who's investigating child abuse go out in tandem with the OCC investigative specialist. So are you envisioning a scenario where now it's 3 entities going out at once? So it's police, DHS, investigative specialist?
Yes, that has occurred actually.
Okay. And then I heard you mention child interviews. So is the approach toward interviewing children by investigative specialists the same as it would be by DHS, which would be to minimize the number of time and hopefully get them to the child abuse center?
DHS is doing the investigation, and they're doing the interview, and the IS is documentation.
Okay, so the IS for OCC is passive, not actively participating.
Right, they're
Our staff are currently not trained in interviewing children, so we rely on the expertise of child welfare.
Sometimes the timing for the DHS worker going out and the police officer going out gets out of whack.
Mm-hmm.
One needs to go out or thinks they need to go out before the other. And in an optimal scenario, they go out together, but we don't live in that world, right? So what happens in that scenario? Who are you tied to, the police officer or the DHS worker? If the officer goes out first before the worker, will you go out with the officer, or will you wait to go out with the worker, or vice versa?
I don't think it would be the worker.
It would be the worker, and I will say that I don't think it's happened, but it's not a common occurrence for law enforcement to be involved in an assessment of child abuse.
What counties have you been working in there?
Multnomah, you would know.
Yeah, Multnomah, Marion,
Okay.
well,
That would actually
Washington County.
Oh, really?
Yeah.
I would say the other way around, that in the vast majority of abuse investigations where the police go out, where there's a concern, a safety concern for the kids, DHS is involved. So that's interesting that found that to be an uncommon.
Yeah, very, yeah.
So I know that there have been times where the law enforcement officer will also join in the tandem investigation, so there's actually 3 people present. Doesn't always happen that way, though.
Can I jump around to some others? Sorry.
And can I want clarification on what rarely happens that the district attorney just outlined?
Look, that there's, law enforcement is not always involved in a child abuse assessment.
But
In
if,
a childcare facility.
In a childcare facility.
so if they go out first for some reason, our staff wouldn't go with them. We'd wait for the DHS worker to go out.
Sometimes we learn it from that cross report, that maybe police have made contact first, and then they've notified.
I mean, if you were to think about a percentage, Mary, like how many do you think are involved law enforcement of, is it like 10%, 20%?
Maybe 15.
Maybe 15%.
Maybe it depends on what you're calling child abuse.
Yeah, that kind of.
Any assessment.
It surprises you because
I
you
would
think
think
the
there was a
police
child
goes
abuse
all the time.
investigation, it would be ours.
If there's child abuse happening in a childcare setting, the police should generally be out there for that, unless you're counting as abuse, I don't know, neglect.
Yeah.
Of a very minor nature,
Yeah.
so like the kid didn't get lunch that day.
Right to the level.
So in those scenarios, or, I don't know, some sort of mistreatment that's just very low level, that DHS would scoop up, but it wouldn't maybe be criminal, but,
Exactly. There's a lot of those
okay,
that we go out and assess that don't elevate to that level. So all those types that Jay laid out that's what we're going out on, all of those that happen in a facility.
So you're talking about things that aren't necessarily crimes,
Yeah,
Right.
is that what you're talking about?
exactly.
Yeah, and I was very surprised when I looked at this list, because from my old relief nursery days, we always talked about abuse and neglect, but had distinctions. Well, Jerry knows, he was on the board, had distinctions between those. And for DHS, even neglect, such as child left alone, serious inattention to the child's needs for affection, is child abuse, according to this handout. So it's just a pretty broad definition in my own experience of child abuse. So I think maybe that's where some of this confusion comes about who's going to show up at the facility.
And I think that if I'm remembering the process right, a call goes in and it like there's screening questions that happen first, and if it meets a certain level of needing to go out for an assessment, that's when the assessment happens, and then it's determined whether or not a law enforcement interaction needs to happen as well, right? Okay.
Well, let's say the one you're talking about, there's a report that, what would you say, you call it child abuse, but it might be, I didn't get fed or something. Would you cross-report that one?
DHS cross reports all of them
To us.
to us.
That's statutorily required.
Would you cross-report to us?
If they've already done that cross report, which typically we've received something from them that says that's already happened, we don't cross report it back.
I think that we would give it to law enforcement. I would assume DHS, and Adam, please weigh in, if there's a potential that there's a crime.
Okay, so if somebody, if you're investigating a child abuse that happens to be, they didn't get fed.
Yeah.
You're not gonna give that to us, okay?
I think, as I understand it, it goes to DHS. DHS then cross-reports to OCC and to the police within their discretion of when they think they're obligated to cross-report.
And I do wish that Dina, I emailed her to hopefully she'd be here, because I also feel kind of where I'm speaking for DHS, and just from my experience, so I want to caution that as well.
From my perspective, if it has any kind of a criminal element to it, it's going to get cross-reported. And then from our office, Otis, we would stand down and wait to determine whether or not law enforcement was going to move forward with something, and then get cleared to do our piece, our investigation.
Yeah, I guess my question is, what you're calling child abuse, in my world, that wouldn't be child abuse. I mean, it would be mean. I mean, you gotta feed your kid, but unless it's
Right.
going on for a week.
Right. So that's what we would consider something that's regulatory from the Office of Child Care's perspective.
It kind of goes to that level of
Definitely
crime
gives you an example of child not eating. So, yeah. Kevin, you have another.
Yeah, I'm sorry. So backing up a moment, am I understanding this correctly? So DHS does all of the investigations, OCC essentially actively along for the ride, but DHS does all the investigations. And then depending on the DHS determination, founded or unfounded or unable to determine, that will help OCC decide whether or not there's substantiated finding of child abuse.
sort of.
OCC will never decide there's a substantiated finding of child abuse. DHS will. We will just look at regulatory violations.
Okay, so then I guess my question is, let's assume there's no regulatory violation and DHS decides there is founded child abuse. OCC will say substantiated child abuse. Is that right?
Valid findings for
I'm sorry, so
inappropriate
well,
discipline.
I guess maybe the word substantiated that OCC uses that you're talking about in the current practice, is that only with respect to a regulation?
Substantiated is the term that the Child Care Development Fund, the federal law, calls founded. So.
Right, that's what I understood. So
Yeah.
if there's a founded child abuse, will OCC report that as substantiated child abuse?
Yes.
Yes.
So what about scenarios where DHS, let's say, do they always investigate every case of child abuse in a daycare facility or in a regulated care facility? Is there ever a circumstance when they wouldn't do an investigation?
It would be only if they closed it at screening, like through the screening process, it wasn't
Okay.
determined to go out.
What about a scenario where they say unfounded and then the police go out and make an arrest and the employee is convicted? What would OCC do then?
We would
Would
still,
that
and so to go back a little bit with your assumptions, there are certain things we don't do. We don't interview children. That was passive. But in interviews with folks like employees of daycare centers or the director of child care centers, we are involved in those interviews in more than a passive way. So I guess what you're saying is we always look depending on, doesn't matter what the DHS decision is on founded or unfounded. We look at the underlying facts. We try to investigate them and determine if there's a violation or not. And so they could have it unfounded and we could have a regulatory health and safety violation.
Okay, so the DHS determination of founded doesn't necessarily control whether or not there's a substantiated violation from OCC, because you're focusing more on the regulatory aspect of it.
Exactly.
Right, but the point of this meeting today is, are we going to post DHS's findings on our portal? That's the nuance for today.
Got it, okay, thank you. Sorry to.
You know, I'm struck by how hard it is for us to differentiate a DHS discernment from an OCC discernment and thinking about the implications for parents trying. If we're having this much trouble differentiating a violation of rule from a DHS assessment of child abuse, think of the poor parent. They're not going to be able to differentiate. This is hard stuff. I mean, we're struggling. We have to keep coming back to OCC only does rules, DHS does child abuse. OCC has nothing to say about whether child abuse happened. OCC has everything to say about whether a rule was broken. I mean, this is hard to communicate.
I think parents care less about the technical legal applications of the words you're using. So if there's a violation of the regulations or if there's a violation of child abuse, we don't really care which term you use. It's all going to mean that something bad happened.
Wouldn't be confused by having two different things there. That's what I was struggling with.
I don't think so. I think if one tells me that a rule was broken and this is the rule that was broken, I would understand that something bad happened, right? And then if one thing told me that there was child abuse or wasn't child abuse, I think I would understand that as well. I think the only complicated part for you guys is that you understand the technical legal ramifications of the specific classification, whereas that wouldn't necessarily matter to me as a parent.
like who makes the call or who doesn't make the call.
Right.
Oh, interesting.
Which is why I think we want to get to the recommendation that's in front of us today, right? And let's focus on this and decide what do we think should be posted on the portal. And hopefully that will help, do what Stephanie's talking about.
Okay. Well, let me cycle back then to the recommendation. But first, the CCDF requirements. They require that we post the aggregate number of instances of substantiated child abuse in child care settings each year, broken down by child care type. Let me explain that. We already do that. We have a page on the safety tools entitled Aggregated Reports. And so one of the reports on this page, so you can go to this, is on our website. It says annual number of instances of substantiated child abuse in child care settings. And so for the current year, it will show registered family child, the 3 types of licensed care, and then also regulated subsidy, and it will show how many instances of substantiated child abuse in the child care settings. And for this year, thus far, we have 3 in registered family and 2 in certified child care centers. So 5, that's what we have. We do not have, and so what the you can't, obviously, if you have a child that goes to a registered family child care center, you can't tell if it's your facility or some facility somewhere else in the state. That's the aggregated data. That's what CCDF requires. That's what we currently do. Our recommendation is to take that down to the provider level and add it going forward. When there is a substantiated incident of child abuse in regulated care, one of these licensors, put the following information: whether there was such a finding and whether it was assigned to an individual or the facility, the type of child abuse, and I refer you back to that document that DHS puts out, whether it be physical injury, neglect, sexual abuse, etc. And then the date it was determined by final order. And that's why I talked about the process. So 3 bits of information. Was there an individual at the facility that was the subject to a finding of substantiated child abuse at that facility? The type of abuse, just the category per DHS's list, and then the date of the final order. That's our recommendation. And that's the end of my presentation.
And then the second bullet in the recommendation is just what CCDF requires about the aggregate.
Yes, I'm sorry. Continue the current practice as well. Keep
Got
the data on the aggregated page because we're required to do so by CCDF.
Okay. So before we break into small groups, which Heidi's anxious for us to do, are there any questions about this recommendation?
I have a question on the first bullet for the recommendation, the one that says whether the finding was assigned to an individual or the facility. Could it be the and/or? Because sometimes you could probably have the provider be the facility director, like one teacher in one facility, so it's one person. Would it?
Yes, that's a very good point and something. So, I mean, I asked my colleague at Otis, has there been, in talking with Dave Manley from from Otis, there's been instances where facilities have received founded. Do you know in those instances whether an individual has also received founded?
So you mean in the same case?
Yeah.
I don't know, because we haven't had one in a long time since I've been there.
Okay.
So we've gone away from looking at agencies as the alleged person, and we look more to individual actions. And in lieu of looking at an agency as the AP or alleged person, we provide recommendations. So when we see a systemic problem happening outside of just what we're actually investigating, we'll notify the agency, kind of wave the red flag and say, hey, there's something going on over here, you guys need to look at this type of deal.
Okay. Any other questions on the recommendation?
When you use the term, Adam, when you use the term agency, that you're going to notify, who is that?
So for instance, we look into, so our adult team will look into Oregon State Hospital abuse and neglect allegations. And so at the conclusion of our investigation, the notification goes out to the agency, so Oregon State Hospital gets notification of the outcome. And in doing that, they may also receive a recommendation. So if it was, hey, the the staff didn't do anything wrong here to this person. We found it wasn't founded. There may be something that we saw within that case that's a more systemic problem that was the cause to the issue. And so we're basically letting them know, hey, our recommendation is you look at this and give consideration to making changes.
So in this case of a child care facility, would it be the director or board of a child care center that you would make that to?
I don't know. I don't know what that would look like, actually. I mean, this is from the one perspective I have from the side of Otis, and this is a little bit different, so I'm not sure as an agent, as an office, how exactly that would look.
I think that we're still figuring out all those processes. This is a new body of work that they're taking on, and so we've got ongoing meetings to kind of work out those details to know what that process is going to look like.
Okay, let's break into small groups.
Yes, thank you.
Facilitator.
Okay. All right, so thank you, Jay. You've already walked through the first question. So just to try to kind of mix this up a little bit, Stephanie, would you be willing to join this group over here? And Eva and Sue, and Adam was saying, Eva and Sue, would you be willing to join Veronica and Kevin, and then staff can kind of fill in, and Adam?
So we'll have two. Okay, plus the phone.
Did we have a phone person? There's only 2 people on the phone today. Incorporated into a group. It's usually hard to hear. You know, it's working. Right off the, okay, not too far. It's just that, yeah. Okay, but, and remember, you're gonna do some.
Oh, no, Jason.
Jason. Okay,
So Heidi, I think we ought to meet down
come down this way.
there. Move so Adam, they haven't actually done this. Yeah, I mean, you've done a lot of it, but you haven't done facilities yet.
No, not sure.
But, I mean, I don't mean that you don't know this field.
I'm
That works. Thank you. Okay, we can move Kara.
So, Kara and Shannon?
I can turn on audio.
Yes.
Might be easier.
Jason's going to facilitate your discussion.
Okay.
I'm going to defer to him in the best way to do that.
Yeah, I'm debating too. It might be easier to go to the bathroom if it's so loud. And I can just turn audio on the computer.
I'm not sure how that works, but yeah.
Or either do
Try
I.
it.
Maybe we're just gonna try.
You can try.
No, they're gonna come through here. It won't come.
I mean, we can mute everything except for one of these, and you could go over there.
It's just loud. Can I hear through here too?
Can you guys talk? Oh, no.
Can you hear us?
I can. Yeah, I can hear you. Okay.
Hi. Oh, they all have to be on or all off.
Okay, I can hear you now. This is Jason.
Hi, Jason.
Hi. Okay, so we're facilitating. Hold on just a sec. I got this all set up for something else here. We're just starting here on the recommendations. Or?
Yep, so talk about.
Okay. Okay. So, Kara and Shannon, what do you think are the pros and cons of the recommendation for the providers and facilities here? Of what the recommendation on when we're going to post substantiated info, and if we are, what are your feelings on it?
I think my only concern, having been at a provider where there was a case where one of our staff members was being investigated, it was based on something that did not have to do with my program. And so having, whether the finding was assigned to an individual or the facility, if it was assigned to the individual, it doesn't seem fair that it would be on the facility's listing on the portal.
Okay, and this would have been something that happened at their home, or did it happen in the center?
It did happen in the center, but it was something that was specifically trained to not happen in the center, which the investigation came back unfounded, which was awesome for our center. But the Office of Child Care finding did come back unable to substantiate. And so it will be on based on, I mean, if the recommendations that we've made through this group go through, then it'll be on the portal for 2 years.
The unable would be, yes, on the allegation.
The unable to substantiate, even though it specifically had to do with one staff member who was no longer with our facility, who was trained not to do that and was fired because of it. The unable to substantiate the question of it maybe being true will be on the portal for 2 years.
Okay. Now, would you feel better if you're able to give responses to those, which you can now, and then, but a parent would have to click on it to read it? Because would that help?
I mean, maybe. I don't know. I think that's something that I've had with the portal anyway. If it's something that is happening with a specific staff person, like it seems really strange that it stays on the facility's record. Which, I mean, I guess maybe that's on the supervision of the program and whether or not the manager is doing what they're supposed to be doing.
Okay, let me see here. I'm just trying to type some here. What do you think, Shannon?
I mean, I guess it's listed there in the cons. The provider may have resolved the issue, is a con from the provider's perspective.
Okay, and then it just stays there for, even if you did the right thing, you fired the staff right away, it's still sitting there for everyone to see.
Great.
So would you want an opportunity then to state the corrective action to that? Hey, we fired this person as soon as they were alleged to have slapped a child. Is that kind of where you're heading? Or you just don't want, or you're just kind of not sure it should be up there at all because it's tied to a person and not the facility?
It feels like if it was assigned to an individual and the individual is no longer at the facility, it should not be posted on the facility's portal.
Okay. That part, it's easy for me to type here.
Like, for me, that if they decide that it has to stay on the portal, that there is an opportunity for the center to do a response for sure.
Do a response.
Yeah. Or even like a word like I mean, like some of the ones we were talking about before, that it was they complied, and a code word of some sort that a parent will understand that it's been fixed. Does that make sense?
Like for the valid and corrected one, is that what you're thinking, Shannon?
Yeah, using the one that's been corrected. Because you were able to, you let the person go, so it was corrected.
Yeah.
Okay. Makes perfect sense here.
So they could put corrected and maybe a response.
Mm-hmm.
Okay. Let's see here.
I just think it finalizes it for the parents, like, oh, it was taken care of. Let me see what it was. Oh, that person was let go. It wasn't the facility. It was something the person wasn't doing. They corrected it. And
yes, I mean, a teacher got upset, slapped a kid. We fired him that day. You know, we did everything we should, basically. Okay.
And we did a training on something, you know, whatever, you know, what's your corrective action?
Right.
Okay, let's see here. So when is it?
But I think, you know, if you have it the way it is, and they don't, you don't have the word corrected or whatever, people are just going to see the complaint. and the issue and not look at it a little harder. Oh, I'm going to bypass that one because there was an issue. I'm not even going to look at it. But if there's a word by it that says,
no, I absolutely understand. You get caught on the allegation that's posted there before you get down to the example. Like you just assume, okay, so that's provider facility. What do you think is useful for the parent and guardian then? So that's kind of the pros and cons for kind of the same thing. The parent would know it was corrected. We were kind of touching on all of it, I think, at the same time. The parent would see that the facility took action. They did the right thing when they found out. Is that a pro for a parent going for? Or?
Well, I think a con would be if you didn't have like the word corrected or things like that, it would be complicated for the parents to understand the whole situation.
Right.
And how it was resolved.
Which I think it might be complicated for the parent anyway, because, I mean, even right now when there is a compliance visit, it's listed in like 4 different ways. So if there was a compliance visit and nothing was found out of compliance, great. But if there's a complaint visit about too many infants in the classroom, and then the licensor also sees that, I don't know, kids weren't washing their hands before lunch or something, each of those things is then listed separately in the portal. So it looks like but I mean, I guess there was a lot of compliance issues in that type of case. But if there's a substantiated incident of child abuse, then there's also going to be compliance issues from the Office of Child Care. And so it's going to look like there's like 4 different listings of child abuse. And so we need to figure out a way to streamline it.
Right. How would that work that you're talking about?
Yeah, because there would generally be some regulatory stuff after. I understand that.
Like Bobby said earlier, it's already complicated for us. I can imagine what it does.
Oh, absolutely.
You know, I think the first thing they're going to do, they're going to look at this whole list and go, hey, I don't want to take my kid there. Instead of looking into the deep part of it, you know, they're not going to, I don't think a good majority of the parents really dig deep to the whys and the hows. They're going to look right there in the portal and see it and move on to the next.
I absolutely agree. You just get caught on the allegation, especially depending on how the allegation is written, and that's all you're thinking about. Because if you start thinking smoke, fire, all that stuff.
Well, that would be a con. They just get. I like how you say that. They get caught on the allegation.
Okay. Let's see. Really, do you think that pretty much covers what we were thinking then? At the provider, there was staff, so it's tied there. So basically, if it's on an individual, it's no longer at the facility. It has to stay on the portal provider. I'm just putting my type notes back together here. I'm sorry. Now, do we really think, is there any pro for the parent that we identify? I got the cons for parents. Is there any pros for the parents? Because a lot of times, if abuse is at a certain level, we're probably shutting the facility down if it's a home. Centers are a little different. But
I think what you've got there is pretty much what I would say is the pro.
Okay.
But I think if I move back to the provider pro, I don't even know, and this is just sort of my experience as an R&R, that I don't even know the provider would have an opportunity to have a dialogue because parents are going to pass them up.
If they're getting it there, and especially since, truthfully, on the portal's licensing history, so there's not even, for a home-based care, there's not even contact information on there because it's odd because of statute, we're not allowed to show their address or phone number. A center we can. So if you're getting to a home provider, all you're going to see is that, and you have no way to contact them unless they come over to see you, Shannon, you give them a referral, or they call us and I think we can give them information. how to contact the people, but it's just basically a licensing snapshot.
Right. But, I mean, I don't even know where the dialogue would happen. So.
Sure would either. So I understand. Okay. I'll put that in.
Yeah, you would only be able to have a dialogue if they were already enrolled. And if you have an already enrolled family that's now visiting the safety portal to look into your compliance history, that family's already upset. They're not looking to have a dialogue. They're looking to see if they have a complaint that lines up with any of the complaints that are on there so that they can submit their own complaint.
Yeah, okay.
Right.
Yeah. Okay. All right.
Yeah, I don't know.
Yeah, this is a tough one. I get it. Okay. All right. Well, I think unless you guys got anything to add, I think that pretty much covers it. It wasn't too much to cover on this one. Are you comfortable with stopping our? You guys have led it. I haven't done anything, but anything more to add here?
As far as I know, I think that's all I have to say.
Yeah, it's pretty cut and dry on this one. Okay. All right. I will, I don't know how to mute you for now, so you don't have to hear everything, unless you want to hear all the background noise.
It's fine.
Which is family friendly. Always care for your players that are their own, and they're not regularly looking at you. I don't. There's a lifestyle one finally registered. I know it's not just regular, different context, registered has a little bit more training requirement, but is there potential requirement too? So you have to go up in that you have more training hours, not certified.
There's going to be a severity scale on the child care violation. That's coming.
Yeah, so we do the same kind of stuff. And then anybody, I mean, that would have to come out, that would have to be like some of the DHS registry. Yeah. A lot of times, providers will have family and friends.
I'm all for, I've asked, parents, I'm all for so, the first one was the, I guess.
All those background registration.
We're all about getting parents too, but give away the farm, on an internal investigation.
Anybody that's employed at
We fire them.
there's now an additional layer of regulation where if it was a situation and you guys said that it wasn't 5 years, and then have to go. I don't know whatever. Does it say she didn't pay?
Yeah. That's the question, though. So it's
My question.
only being.
We're talking about what is recorded. What do you need to say? So, give it after.
Having that is insufficient information. I'm not there. I'm just.
Like I said, it was medication, and it was probably.
That's not in regulating here, I guess.
They're on their break, so, but if they're in a car, something like that, doing that, then at that point, it.
And if they're, let's say they've used their own.
been investigated for child care, that would have to law enforcement. And that would go into CR, and often child care would say this person even last or child care. Or if, okay.
Parents, of course, the kids' facility would have no way of knowing that. I'm just asking, I'm not, I mean, it's better if we have to go through the employer. Let's do it.
Right, like you said, the employer doesn't know, and then that person's doing that on their own time, and then they get arrested, and then often the child care says, you work at the facility anymore, that person is then.
Providers are.
Yeah.
I'm just, I'm not saying.
So what would that, would it be for the parents to know that? Like, I don't know, I wouldn't want that to be, well, that's just what you're talking about.
I guess, in my, I have a compartmentalized, but if you got, say, an employee, had employee using one compare other my model, child aid, how well child is being cared for. Child aid is a disability, clearly it's important. But if child aid, next door, parent's house, right? So there's a distinction clearly here, which is where the kid is used by the employee has an impact on whether that active use gets reported on the portal, right? I'm trying to understand that.
I think you're right, that is the way, and I think it's because we're on authority. So this recommendation, what
And I'm not,
regulation over.
it's not regulation, it's just a matter of, it's shining a light of day on what we facts that we know, right? So this isn't a question of whether, everything was in the parent gets to know there's different information.
The parents get to know that an employee of a child care facility that no longer works there, it was not,
Well, the employee,
suspected of abuse in work.
but it's the deciding factor is whether the employee is arguably any scenario of employees don't work there, and then right? So let's say you got learning tree, daycare, and the offending employee no longer works there. So if that were the standard, then none of the employees after the injured child abuse is regular care, rather than for the employee not.
And that's, okay.
You know what?
I'm breathing for me to say, because I'm a chronic overnighter.
Well, it's pretty common to have people that engage in child abuse now actually not occur in the facility, and what do you do?
It happened in the facility,
But it resulted in some crime or some kind of behavior.
right.
That person.
Has to be, what to do.
I'm just asking what it means to say.
While they're at work, given that information, I feel comfortable with this recommendation because what happens,
And that's,
severity of the patient.
what about like an in-home scenario where we've got, maybe I don't know, but where you have in-home child care facility, you've got, let's say, the home, you're not doing the child that's,
If the provider's own child is at the facility or home, and it's during child care, during other child care. Right. Your child is in supervision of the provider, yes.
it has to be a kid that actually needs to survive. It can't be like a sibling.
So it's like,
No, if there's a sibling in the house, so like 15-year-old sibling, too young to be single back across the street, but, and is child of child care provider,
Anyway, so I still have this kind of mid-lane. Some of them obviously want to rise to the level of thinking. If I'm gonna pass it up.
Internal investigation and then then there's like an internal sort of appeal process for child welfare. And there's other than.
For a founding child abuse.
But in both those situations.
No, for a founding child abuse, where, here's the problem.
And then final order issue. The folks who still then appeal to the regular courts outside of that, but DHS decided that final order gives the opportunity for them to say, wait a minute, you got it wrong. But on the other hand, they wait forever. So we're looking at a timeline of what is on the response like 6 months. That's the timeline. DHS. Then I talked about, so child abuse can occur, so the date is going to be somewhat.
So you wouldn't necessarily pass about the date with one. Is it clear that that's one individual? Information go on, but until you work by the law. And then I'd ask the question.
Yeah, and
All right, team, let's start wrapping up.
Was there a thought about putting the date?
Talk with DHS, their information, we're asking you. Could we make a recommendation or renegotiate with DHS?
So go ahead and
Wrap
up.
Come back together.
I maybe with this question, how long that take you, that final order? It's a long time. Final order might not have very hard. It's your parent wondering when did this happen?
So it's not the appeal, it's not the external appeal, it's for the appeal.
All right, let's go ahead and wrap. Let's take a 5-minute break once you finish your last sentence. There are some challenges
Yeah, there's like
you can eliminate if you want to wrap up. So I guess, what do you think as they're looking for childcare?
That is the question. So I think that he said, without knowing the severity, if child abuse and it's substantiated.
It is understandable that maybe.
I think, yeah, and I think that's the question. The portal is, they have
How much information do you want in that? Is there under investigation? Under investigation.
I want to be able to have enough information.
A wide array.
Yeah.
I would want to know. My point is that what in the parent term, me and a substantiated, we're going to assume that it's a big step.
So we're taking a break for folks on the phone, Shannon, Kara. Oh, Kara.
Okay, thank you.
We're coming back together at 4:30.
So take, for example, the incident, so that is a more sensitive investigation. Our finding is they violate by doing content, that would go up on the corner. We're done with our investigation. But the DHS investigation is the same. You have one aspect, yeah, on this stage, somebody hits somebody, and so you have to find it. I want to say off the top of my head. Well, we took those, yeah, I mean, if we took that, I mean, depending on who you are, violation, but that includes terminating as well as finding those. Yeah, that's what we're looking at. There's a whole bunch of actions going on, some of which is reported to our information. We'll get a.
Yeah, in that case, the employee's no longer there, because there is still an investigation, you know, use going on. The employee's no longer there, by the employer, it has to take care of.
Why do you say?
So it has to cause harm, as we didn't know that there was a.
Right.
Well, yeah, but it's some of the, one of our, well, or some are,
I'd rate that higher too. That's not much you get.
Well, I was reading like how selling,
That rang really fast.
really hot, I mean, not, I wouldn't.
I would know what you're saying is, or let me ask you, just, maybe have a category of thing here, recommendation. So that as a parent, you are aware, okay, unresolved questions out there.
That's the highest, yeah, I don't think that's on, it's not, I don't, if it's the provider damage to the reputation on the basis. When for a lack of parents,
I think the way you worded it, Adam, is meaningful if there's no consequence. You don't know how serious it is. Is it meaningful to post it if you don't know how serious?
You know, what we recommend is second time to add out.
Yeah, I think what I, my action,
Agree with the recommendation. Yeah. But it's not enough information. I
love the way I is meaningful, without.
Yeah, and that's where it's still. Without a pattern, that. It's not an environment trigger. That's an injury on the provider.
You should be close.
Well, we will work on that.
Sure.
So that's useful.
I just wonder,
You know how many of those providers supervision. A kid got injured.
I mean, that's just kind of like, it's really serious.
When it was.
They violated the rules.
Random, running around. And so like, that, I think that's what I was really thinking too, is like, at what point does a parent become so anxiety ridden and fearful of putting their child anywhere? You know, that because all these things are listed, okay, I'm under investigation, I fired that employee, and they have to answer that every time they get a call, or what, you know, like, oh, do you have the availability? I looked on the portal, I saw this, what does that mean? You know, how that, you know, like, you know, so I'm trying to feel what's actually. Yeah.
I mean, I totally agree with that. I know that. For me, if I look at my child care, the fact that employees did something, he or she is later fired, have trial, you wonder, well, how much that is independent action of the employee, how much that is auxiliary. Was hiring that employee, Or is part of what led to that was the supervisor? Any bit of the problem employee.
Yeah, we don't yeah, that does make sense. I mean, then you blame somebody else.
Question we're trying to answer today.
Nice to have a little snack, right?
And so, yeah, it is a weird place to be.
All right, let's go ahead and make our way back.
And then we can hear what
Heidi? Hey, Heidi, you want to put this back out again? Would it be helpful?
Okay.
Yeah.
Would it be helpful for me to take notes again, or no? I don't know, I thought it would be helpful. Turn it out. So let me know if you want me to step up. Okay. If it's Amelia, own it, I will start with the last.
Going back.
So if it was about the provider child.
Okay, let's go ahead and make our way back and, tell you what your discussion was. And
So you are dealing with organizations, but if it's child abuse, a parent, still DHS.
And we're still working on that.
Awesome, thank you. You guys will able to grab some sandwiches there, so we can lunch and talk. Somebody can talk, and then the rest of us too much. There we go. All right, we're, Brett and Shannon, right? Guys, we wrapped up in the you want to share what you all discussed, kind of your key, any additional information?
Sure. So basically, the first one for pros, kind of had a recommendation for provides an opportunity to have a dialogue with parents about the facts. We're actually not sure that's a pro or a con, depending on unless the corrective actions or training is provided by staff. We think there's an opportunity that people are just stuck on the allegation, see that in that dialogue, and they might come in contact with somebody, on the portal, they might not ever speak to that provider, right? Unless there's a way to give an explanation of the corrective actions to a staff member, we're not sure that's a problem.
Did that change your suggestions for the recommendations for your group?
We didn't have a final really recommendation. We just
okay, so we'll come up with the group. We want to do a test for agreement on the recommendations to what to move forward. So, okay. Kind of a discussion on,
and we think it may be confusing for the parents.
okay, great.
Because it's confusing for us after these conversations.
Okay. Great. Great, okay. Anything else, Jason?
Several. The way things are displayed on the portal currently, being that there's allegations, we have a finding for a CPS case, and then we probably have our regulatory things too, and this would be more of a design issue. Then a parent can come in and be confused because it's going to, even though it's one instance, it's going to be, we're going to display it several times. And then so now is it a one-off or is it a systematic issue? And so from a parent's standpoint, that might be, that makes sense. So we have a regulatory finding on the portal, and then you have a CPS issue somehow. And if they're not tied together, well, it's a design issue. It might be issues when really it's
So around the design, usability of it, you'd like to streamline or simplification, so it's linked. But that's more around the design, not necessarily the recommendation or what.
yeah. So basically, if we did have a recommendation, it's given the provider or the facility a way to respond to the issue, to their side of the story, to give us corrective actions.
Okay. So can you say more about that?
So if it's a teacher,
Yeah.
and to a child that was inappropriate, they fired them on the spot. Next, their staff, they did training the next week on that instance, but when it happened again, give them an opportunity to show what they did after this.
I'd like to add that.
Yes, okay. Definitely there's an explanation given by the provider.
Okay. Okay.
I think that covers it. They can
Yeah.
correct me if I'm wrong.
Shannon and Karen, anything else you'd like to add? Thumbs up? Awesome. Thank you.
Sure, it kind of felt like Stephanie and I were looking at each other, that we had similar conversations as Jason and our phone friends.
Okay.
I think one of a discussion, just to try to distill it down, is that without kind of having meaningful content, it's hard that how would this be helpful, right? So if we did, there can be such severity differences in the types of abuse, what's there, that without having additional information, that is going to be challenging. And so, would need to be very clear if it was on the individual, the facility, and there was a desire to really only show those that are serious. Anybody?
Can you say more a little bit about that? Desire to show only serious. What does that mean?
Well, I mean, I think there was some distinction of like a neglect of not, doing something neglectful versus causing harm to a child. So
One-time mistake versus an actual problem.
yeah, a pattern.
I forgot to feed your child once, not every day.
My daughter still goes to that daycare, so the one time, it was still okay. But what we were discussing was, we used my daughter's situation as an example in our group. And give some context to that is they forgot to feed her when she was 6 months old for one day. They told us. We didn't report it or anything. But if it had been investigated and found it to be neglect, if all it said was substantiated neglect, as a parent, seeing that on the portal, that daycare would be off the list. So having some context to what the allegation was important to us. For example, I don't consider that one mistake they made to be abuse of my child. If it became a pattern or they did it more than that, then that'd be different. But whereas something more serious, we would want that to show up in the way that it's recommended.
But we're not sure that Otis can do that. So I think, I think that they could, we're going to move, Office of Child Care is going to move to rating severity of a rule violation, but it's not clear that the same thing can happen on the DHS side.
That's currently not a component that would be able to do.
Yeah, we've tried.
We talked about the potential for an explanation of action taken, and I believe the problem was that information could be confidential and not able to be shared in the public format.
So it sounds like there might be some space. We may want these in the recommendations, but it may be pending what the early learning division can find out if it's even possible.
Yeah, because somebody said if you fire somebody, there's limits on what the employer could say on a website.
Sure, that's true.
They couldn't say, well, don't worry about this parent because I fired her that day.
Right.
May not.
Okay.
Maybe there should be an explanation or a disclaimer about what the portal can and can't do. In other words, whether you say, you need to be aware, I don't know how you word it, I just thought of this, but neglect can be minor or major, and you need to look into the circumstances or something, or you need to call, because the discussion was, and I think you said it very well, or somebody did, if there's a neglect on there, I'm not calling that place, I'm just gonna keep going.
Yeah.
That could be really unfair to
Or maybe there could be a classification like accidental or criminal. I don't know if that, as far as you want to take it, but some way to explain what it is that happens, even if you're not able to give actual details.
I mean, I think if I would sum up of what you're hearing, I don't think people were comfortable with this recommendation moving forward.
Yeah.
That there would need to be additional, clear information that provides the context. Is that a?
Yeah, I think Adam's statement that it's not meaningful without context, therefore are you helping parents if you give them information that's not meaningful with and you can't give the context?
Right, no, that's perfect. I think you said it right. You gotta look out for the parents, but you gotta look out for a daycare operator just as much because, well, maybe not just, I mean.
Also,
Yeah, also.
my feeling on the recommendation as it is is that it would do more harm to daycare than it would add value to parents. Go ahead and hear from the third group, and then let's go back to this.
Okay, and group, correct me if or please add additions if this is inaccurate. So, one of the issues that came up in the recommendation was whether or not there was some sort of group of child abuse findings that wasn't being captured by the founded incident of child abuse by DHS. So, language addition that was that came up was, in addition to when there's a substantiated incident of child abuse in regulated care, or a criminal conviction for an incident of child abuse in regulated care. So adding a criminal conviction. So the language would be, or a criminal conviction for an incident of child abuse in regulated care. So
to differentiate, there's two kinds of rules. I mean, the rules and the...
So to differentiate between DHS and really law enforcement, the DAs. And so we still have the OCC doing its thing, but there's the criminal child abuse and DHS child abuse, if I'm right with that.
So founded cases do not capture the entire universe of child abuse. DHS gets it wrong sometimes. So how do you, if the goal is to report substantiated cases of child, cases where it occurred, and recognize the reality that DHS doesn't get it right 100% of the time, how do you capture that difference between where DHS doesn't and where it occurred, whatever that gap is? And the question was, well, what about a case where perhaps DHS unfounded it, but a judge or jury later determined it in fact did happen? Shouldn't that also be reported?
So it's adding that in addition to the recommendation.
So.
Okay.
There was also in the group a level of discomfort with the date. The date is the date determined by final order. So is there something we can do with the date to have it refer back to the time when the child abuse happened? So even if it's not posted until the final order happens, but is there some way you can refer to the when the child abuse happened from a date perspective?
How big of a gap is there usually between when that happens and?
Well, we're estimating that 6 months would be a typical time frame for a final order. So, and there's also discussion of what it meant to be in regulated care. I don't think we've changed anything. Correct me if I'm wrong, but like, what does it mean to be in regulated care? And perhaps that needs to be in regulated care needs to be defined for the audience of the portal somehow, so that that's clear.
Well, maybe I don't remember, but what was our decision on putting non-regulated facilities on the portal at all?
Well, my question wasn't, so it wasn't what regulated care means, it's what is in means. Does that make sense? So,
No.
No. Why does
well, I don't know if it's appropriate for the entire group, but I think I was doing one with the question.
Yeah, other lawyers.
Jay's talking about it. I said, well, what does it mean to say an incident of child abuse in regulated care? Like, what happens if the employee, let's say, is doing something child abuse-ish, and that's not in the building? So let's say he's looking at child pornography in his phone on a break.
In his car.
What's that?
In his car, you said.
In his car.
Mm.
What I said.
Yeah.
Or what if he's using his own kids but not the ones in the facility? Got to accuse him
From the.
I'm not going to say by who. But, so maybe that neither here nor there, but the issue didn't have to do with like what is regulated care, because I think we've already discussed that one. But for me, it just has to do with, well, what do we mean by in? I know, understand it. So no one else has a problem with it. I don't know if we did spend time on it.
Would this be reported to Office of Child Care if it was his own kids?
I think it would just be law enforcement.
The CBR, he'd be kicked out.
Kicked out of the
He
CBR.
couldn't work in a child care facility.
That's the other safeguard that is there.
You've got child care facility X, and let's say they've got 4 employees, and one of them is a prolific child abuser. Just
They can't be. The CBR would have, not if he's known. He wouldn't be
Oh, unknown, okay.
So let's say you've got a facility, and you've got 4 employees, one of them's a prolific child abuser, and of the kids he's abused, those that have come forward are not kids in the facility. You know, they're kids at the soccer team that he coaches.
Wouldn't matter.
So it wouldn't matter, so it would never get on the portal, even if the facility has employed this prolific child abuser as an employee. That was my question. What's the meaning of in here?
CPR.
So, I mean, we talked about it'd be a separate action to remove the person from the central
absolutely.
background registry, so they could no longer work at a child care facility. But if the incident didn't happen at the child care facility, it wouldn't go up on the portal. They just wouldn't be able to work.
Oh, but he couldn't be there anyway,
Couldn't be there anymore.
because he couldn't be hired.
Unless, you know, somebody came forward from the facility itself saying it happened.
It was not known.
Yeah.
Okay, Jay, anything else?
That, I think, captures the points we discussed.
Yeah, and then I just wanted to add one thing, was, the thought came to me when everybody else was talking. So, because the explanation is so generic, it doesn't have a lot of meat to it. I can see parents looking at it and they would want to know more, so they're going to call us. And so that's going to generate phone calls that we're not going to be able to answer for them because it's not our info. And so we're going to
I don't think
redirect.
parents would call.
They're just gonna walk on by.
I think if I see a daycare facility that has something that's generic as child abuse on there, I'm just gonna skip them, cross them off my list and move on.
There's parents that do call also as well because they want to know. They saw it and they want to know what it is.
Do that.
Yeah. And I just feel like that's going to cause some generating phone calls that we're not going to be able to answer, end up redirecting to DHS because they're the owners of the information.
Yeah, you know, Mary, you're raising a really good point, in that there's authority limits that Office of Shelter has in this whole conversation, because this is DHS's work, basically. They're really simple. So what we're saying, I want to recap what some of these recommendations we've had. They would need to be examined if they can be even move forward, because this is not necessarily an Office of Child Care authority. Some of these pieces, we're going to do a check on that. But you raise a very good point.
Just a point of order, the actual recommendation, we've talked to DHS about that, and they've given that, we have their blessing for that. So if we change, it's the changes that we'd have to go back and talk to DHS
Okay,
about.
so again, clarity, this isn't even an Office of Child Care decision necessarily. We're seeking your feedback, however, this is going to go to another DHS for that final, DHS and the Early Learning Council. Thank you.
Lucky, we had them together with
Working together, thank you.
the messenger.
Sign
Often
the
don't kill the messenger.
I was gonna say, I really appreciate what Stephanie was saying about, the provider and, like, provider and parent, because, you know, if we're not smart about what information and how much information we're putting on, like, it, you know, well, and coupling it with the confusion that we've all had with what does all this mean, you know, like, we already have a child care desert for infants and toddlers statewide, right? And other parents have trouble finding preschool care, after school, you know, like, it's a problem. So, yes, keep kids safe. Yes, let's find the smartest way to provide information and transparency, but let's not put the fear of there's no place safe to keep my kid. Let's not have all providers living in this fear that they are constantly going to be accused or shut down, you know, accused of abuse or neglect and getting shut down, because it's not going to help us support families and kids, you know, it's not going to help us support keeping providers in the business. So I think, you know, like, what is the useful information that we can do and what's too much? So I really appreciated what you were saying about, you know, if that's going to be there, we need to have it carefully defined or not include something that's not serious.
So let's just back up what we heard. And I want to do a check-in with you all, but also Office of Child Care staff here about next steps, given we've got different lines of decision-making here. One of the things we heard was an opportunity for providers to explain. We heard some design things and some suggestions around clarity. We heard you want some clarification or some additional information around the level of seriousness, so to add some context and information to what the allegation was. Add a disclaimer on the portal. That's a little separate to this recommendation, but it's add an explanation or disclaimer on the portal, what the portal can and can't do. Okay. And then we've got adding language around criminal conviction in the recommendation, and include the date to refer back to when your child abuse happened, and clearly define in regulated care. So let's first take opportunity for providers to explain. Office of Child Care staff, I look to you for what's possible or what your suggestion would be.
I think one of the issues is we're posting another agency's finding, and so we're sort of giving the opportunity for someone to collaterally attack that agency's finding on our portal. That's just a thought that crosses my head.
Okay. So that may or may not be even doable.
I don't know the answer to that off the top of my head.
It would need to be explored. Okay.
So all of these changes are going to have to go to DHS.
Exactly.
Bottom line.
All of these bottom
Because
line.
it's theirs.
Right. Right. Right.
Well, is it theirs? It's really yours, but your sole determining factor is what they've decided, right? You're saying substantiated, and then behind the curtain of what counts as substantiated is just a question of the DHS say it's founded. Right? No?
No.
I thought substantiated occurs when it's found in DHS.
So I think, are you talking about a child care regulation versus finding a child abuse?
I guess I'm talking about a substantiated child abuse incident,
Okay.
which, as I understood it, maybe I'm wrong, that alarm bell goes off as a substantiated child abuse incident. It just determines when it's founded.
Yeah.
That's correct, yeah.
So you're not putting on the portal DHS determines it's founded, you're putting on the portal this is substantiated, right? It's your finding.
To me, it's the same thing. To me,
What are you putting on there?
we're putting on DHS's founded.
Oh, I thought you were putting substantiated.
I view those words as synonyms. I mean, we could change the language so it could be, I view those as synonyms, not that I'm making a determination that founded is substantiated on some, like, legal level. It's just that it's a synonym. The word means the same. That's.
But you're not, when DHS has a founded incident of child abuse?
Yeah, we can change it that the substantiated language comes from the CCDF. That's their language, and states call their substantiated child abuse whatever they call them. But we could certainly put on our portal founded, use DHS's language.
And can we assign it to DHS instead of there is? Can we say when DHS has a founded incident?
Sure.
Finds it?
Yeah, because that's what we're doing. It's this language.
As well. That would help clarify when people call you as well, that they would already be prepared that the answer is going to be DHS has that information.
But I think I want to be clear. Whatever DHS says based on their rules does not have a direct impact on what you decide fits regs or whether it's a violation.
Correct.
So OCC is following its own set of rules. DHS is following its own set of rules. And all that we're talking about is posting them both
Yes.
on the same site, right?
Yes, and today is only about posting DHS's. We've already talked about ours.
Okay.
That does bring up that first, what the phone group mentioned, though, that if there's two postings, it could be misinterpreted in two separate incidents.
Right. So tying together whether it's
They're directly related.
an allegation, violation of child care regulations or a child abuse finding. Be making that clear, right? you want to make that clear.
And then probably channeling those calls, those parents to the proper either DHS or not. That way there's not a confusion of, oh, I called here, so I'm going to be transferred, or now I have to call again and wait. So that it's just kind of making it clear.
Yeah. Again, just more clarity. More clarity, right, okay.
I have an information question. So if DHS did not find child abuse, but somehow the court system did, how would Office of Child Care know that?
No, if there was a conviction, it would show up on our LEDS check. I didn't have it cross-reported to us. So every quarter, everyone in our central background registry, we go through and do a check to see if there has been any arrest, any conviction.
Wouldn't you wait, if there's a criminal case against somebody like this, wouldn't you wait to post something until that case is done?
Yeah. I think it would be if
I mean,
something.
it would be pretty weird for you to say,
Conviction anyway.
I mean, if DHS knows when we're investigating someone, so there shouldn't be a posting until that criminal case is finished. That shouldn't happen.
That's that final order date.
Huh?
I think that's that final order date.
Right.
That's when it gets put on there.
That's exactly right. I agree with you. And so there shouldn't be anything on there until
Not until it's final.
it's done.
Yeah.
So, given that we need to provide something back to the Early Learning Council, and as Sue already articulated, these are things that will be need to research for feasibility with DHS within the Early Learning Division. Can you share your comfort level? How comfortable are you with moving forward with the recommendation, with knowing that these will need to be researched for feasibility? I mean,
Moving forward with all of these changes to the recommendation?
researching these for feasibility. All of these pieces.
There kind of is no recommendation until we know the answer.
Okay. So you guys are not comfortable moving forward until you have a response?
Well, I don't think there is a recommendation until we know. Like we heard that you can't.
I think it's fair for my
that-
Okay. So Angela and Jay, I turn to you, as we're hearing from the group. As staff leading this work, and Don, you too.
So if you're asking, can we explore all these and report back to the committee, we can do it.
I am a little concerned about the time with it under which we have to wrap up this committee. Our last meeting is next month, and I would like to say we can promise to get all of these questions answered, but within that time frame. But I'm not really sure that it's feasible. But we can certainly do our best. Something I'm curious about is, does the committee, are any of these items, so the current recommendation as it stands, it sounds like, if we didn't get any of these approved, hypothetically, we could do none, a couple, all of them, in those potential scenarios. So the first one is, we don't get, DHS says none of these are feasible. How would the group feel about the committee recommendation? How would this committee want to make modifications to this? Or does the committee think that recommendation is important enough, is something of value that we would want to put forth as is, if we couldn't add any of those? My first.
Because I think the fallback position is the status quo, which is all we do is provide the aggregated data, which CCDF requires, and we do nothing else with DHS findings on our portal, right? That's a fallback.
I think this recommendation is exactly why we all got together. This one more than any of the other ones, because when you contacted me and said, "What are you doing?" I said, "What are we doing?" You said, "We're going to look at what goes on the portal about injuries or things to people, kids in childcare." I think this is the crux of why we're getting together. So we got to hammer this one out before we're done, I think. Maybe I'm wrong. That's just a opinion.
No, it's a good point. And yeah, Adam, we're sending you that with quite, along with our staff, but it would certainly be helpful to have DHS Child Welfare, whomever that might be, either listen to the tape of this meeting so they understand how many scenarios we've put out, and then have them actually help us figure out what information can we put on our portal to inform parents.
We can definitely go back and ask that. From our initial discussions, and again, I don't want to speak for them, we'll take it back, and I think it's going to be pretty limited what information we are able to put up on the portal. That was the message that I heard.
I think, I just want to say that Adam said it the most clearly to me. I mean, he said it to all of us, but it was the most clear message to me is the information meaningful to parents if that's all they have? If there's no context. And I don't know what people think. I mean, my reaction is kind of not very. Could do a lot of harm.
Leaves too much guesswork.
Pardon?
It leaves too much guessing, of what are they talking about when we're just giving them little blips of, when a lot more.
OCC puts on information about a finding or an allegation. There's information as what that is. Without that information, it's just going to cause fear.
Mm-hmm.
Other thoughts about it? Is it meaningful, guys, reflecting on Bobby's question?
Let me be the contrarian for a second, just for our conversation. So right now, it's completely devoid of any meaning whatsoever for parents, right? It's aggregate data that doesn't have any specificity, or, I mean, basically it's like saying, somewhere in Oregon, something happened, some kid at some provider. It doesn't, it could be the one down the street, or it could be the one 300 miles away. It's devoid of meaning, unless you're like a statistician or a data geek, want to know more about what's happening to kids. So if we do nothing, we quite literally are doing nothing. Then the question is, well, is there an added benefit? In my mind, as I think about it, is there any, what's the gain and what's the loss in providing some data? And there has to be some level of certainty. So the substantiated incident language is, I think, what was proposed. And then the concern, I guess, would be that you've got, maybe it sweeps up too much stuff, but there's nothing less than, there's nothing higher than substantiated that you can use as a determining factor that I'm aware of. So, I mean, yeah, the downside is the parent might get, I guess, worried for no good reason, but me, I would rather have more parents be more concerned than fewer parents not having the information. Because right now, we're not giving them what they need. That's the reason we're meeting. The system is not doing what it needs to do. So I don't think we can go forward and continue to do nothing. I can't think of another way of articulating a dividing line. So I am in favor of doing something along the lines of this recommendation.
All right, we definitely do not, I mean, it sounds like you would like to find out what's feasible in order to be able to move any kind of recommendation forward. And I'm a little, go ahead, Angela. Go ahead, Eva.
I was going to say, to counter that, I think, we can't do all the work for all the parents. Parents are going to have to call providers, go visit providers, find out what's a good fit for them. And so having, having information like they've been visited, there weren't any, like having some information, yes. But like, what, at some point, onus needs to fall on the parent to be able to say, I need to go and figure out where the best place for my kid is. And that means taking the time to go visit. If the provider is not open to having you come into their facility, whether it's a home or a center, that's a red flag. If they're not willing to share names of other parents, that's a red flag. Because part of early learning council is to develop support and get parents engaged in their child's lives. So how, if we're just providing all this information that's an overload and sets fear into their minds, how are we getting people engaged in these conversations, and how are they not ensuring that it's the right fit for their kid to be in that facility?
So who ultimately asked you to put this group together and come up with recommendations?
The governor.
Okay, so if the governor, if we were done and we showed the governor this, and so this is what we came up with, would the governor be pleased with that result? And if the answer is yes, then we're done. If the answer is no, then we got to get those questions. Then we got to get those questions answered, because if this is, and maybe the governor didn't know what the governor was looking for, but I mean, that's really what it comes to.
One of the governor's primary focuses for this committee was the parents. She really, really cared about getting the parent voice, saying, what do you guys want on this portal? So what Stephanie has been talking about and other parents at other meetings is of primary importance in weight, I believe. Providers obviously are also a critical part of the equation, and the governor wanted to make sure that we were listening to the providers because we've got a provider deficit in this state. So their input, so it's the balancing out what parents want and what's appropriate for providers. I think with the input we had today, if there were a way to refine these 3 bullets enough so that we could provide some of this context, which is sort of the word we've been coming up with. So when it says the substantiated type of abuse or neglect, I assume that means which category here.
Correct.
And so somehow putting more context, I guess, even around these bullets could be helpful. But I mean, if the parents are saying this information isn't going to provide any help to us.
I do want to clarify.
Okay.
Because this information is important. But if you make it too vague, it's not going to be useful. We need to make sure that this information is provided in a way that's helpful and not just harmful. I don't think, if I had to choose, as the parent, if I had to choose exactly as it is on that recommendation or exactly as it was before with no information at all, I would choose the recommendation. It's just not going to be as useful as I think it should be.
Well, I think that's great, and I appreciate everybody's contributions, and what that sparked for me was, what if, because I don't think that we can say, let's say theoretically DHS doesn't approve us to do any of these things, but I feel like what the Early Learning Division and the Office of Child Affairs could do is provide guidance about what maybe right with any stuff like this posting of this information on a provider's page, along with any of that posting to give like steps to take to find that to explore this provider. Like we could provide a little statement of, so it's kind of like a disclaimer, but it's our guidance. It's like a little statement of, call your provider,
Right.
Ask these questions. These, there are many different possibilities that would contribute to, there are lots of pieces of information about this that
they're important for you to know. So that's why we're sharing it, so that you can have X, Y, Z conversation with this potential provider, so that it's giving that we can frame it, the language could be framed in a way that's like giving acknowledgement to providers that have taken the right steps, that that's a possibility. And really, it's a kind of relates to one of the pros, it's like sparks the discussion. So that when you're exploring this potential provider that maybe has had an incident of child abuse, we could give some, it could be the language that goes with any posting could give you, the parent, some guidance as to what to do with it.
Yeah, that's a great idea. And I think one of the other comments floating around somewhere was to give the provider a chance to have some kind of.
That's back to the we would need DHS's approval, I think, to do that, because it's DHS's information, is my understanding.
Okay. Let me ask.
This statement about like how to engage with your potential child care provider is definitely in our lane.
Right. So Mary and Dawn, how often will DHS have a finding, substantiated finding, and we will have nothing?
What do you mean?
Not frequent. I mean, that we wouldn't have any rule violation.
If there was a founded for abuse, we would,
There's gonna be a fine.
there's gonna be a rule violation, there'd be a.
Okay, so one thing that would help me for our October meeting, so me, Angela, and Jay, is if we had sort of a context for even these rules, because everything we've done up until this point has been what we have some control over. So how much information are we going to be able to put on the portal under our own decision making that would still provide context for somebody who went on to the portal and found, Operation X? We can say what happened there, even if we can only use DHS's limited language. So
You could still rely on what OCC has
Oh.
for their findings.
exactly, because we can post that. So
You post that.
do post that.
Yeah, that wouldn't be anything new, certainly.
And that could,
I think it's the connecting it.
that could provide the context if you made it clear that that was one and the same situation.
And there
That goes
should be a
back
way
to-
to do that.
That goes back to the date, maybe.
Functionality and the,
Well, and Jay, we did have a question. Do programs survive getting a child abuse substantiation, a founded child abuse? Are those 5 programs still in business?
The ones on the aggregate, I don't have that
The
information. but
aggregate ones that you posted, they're still in business?
I don't know the answer to that. I
one
need to
out
check
of
on
it.
that.
I'd like to know that.
Okay, absolutely.
You know, what might be helpful as examples, we're talking in the abstract here, but what are some examples of founded child abuse that have been reported in the aggregate, like what specifically happened? Because if we had those case examples, I think that might help ground us in what's actually happening on the ground versus, our different theories about what we're thinking of. Do we have those at the ready right now?
we wouldn't have those now, we'd have to bring them back.
Okay, but there's only, what, 5, is that right?
Yeah.
So what we're talking about is pretty rare. 5 in the aggregate over the course of the entire year. And I suspect once we look at those examples, it's going to really help us guide our conversation.
I do too.
I agree.
I agree.
Okay.
I mean, because, maybe parents should not take their children there. I mean, that's what we don't know.
If in order for it to be a founded case of child abuse, it has to be super severe, then we don't need more information than that.
Yeah, I mean, I guess I would need to know I want to see the examples, but if you look at this list here, I mean, I'm talking about an intentional inflicted injury. Tell me the one that you wouldn't want to tell a parent about, or, sexual contact. When wouldn't you tell a parent? Or child selling, I mean.
Well, I think the one that keeps coming up is the staff member who slapped a child, the director fired the person on the spot, but it still happened. So it's still valid child abuse, right? So you have the thing, but the person was gone. And my understanding is that can't get posted, that you fired them, can't get posted.
The fact that the facility fired the person doesn't end the inquiry for me, so, you know, we mentioned this in our small group, we were talking about it, but does that mean that the facility made a bad decision on hiring, with improper screening, training, or supervision of that employee? I mean, doing away with the wrongdoer doesn't do away with the risk of harm to the kid. I think a parent has a right to know and make that decision. Parents won't know that, they won't even know to ask, or if they ask, I mean, what facility is going to say, who's going to volunteer this information if it's not already out there?
Well, I think Chief Moore's comment was, you can have all the great processes in place and make a mistake in hiring. You still can. I mean, you know, so those are the kinds of issues we were trying to struggle through.
Well, I think a little bit, and I call it a disclaimer, but I think you said it, you have to develop a relationship with whoever it is you're going to take your kids to. And it goes back to making the phone call, and because you're not going to take them there if you're not feeling comfortable. And the only way you're going to do that is picking up the phone, I guess, or knocking on the door.
What's really sad is parents do take their kids without even making a phone call. It's really sad.
Well, there's drop-in care, so some parents aren't able to do that, right?
They're not licensed.
Emergency.
They're not licensed.
Like the emergency.
Drop-in care is never live.
I don't think, no, because you have to have ratios, right?
No, there's drop-in. There is a few drop-in facilities. It's a very hard model to manage as a business, but you can be licensed and you drop in. You just have to have certain safeguards and ways to have staff. It only takes so many.
So most of them then are not licensed.
Most of them are not yet.
So it seems to me, Heidi, that we're at a point where we'd love to have the 5 examples at our next meeting, so we can try to get a handle on this. I think checking with DHS, seeing if there's any wiggle room after they listen to the 2.5-hour tape of this meeting. I'm sure they'll do quickly. And just see if there's any flexibility in this to try to respond to some of our concerns. And then we will come back and, you know, the idea of putting in the criminal conviction as alternative added language, they may well agree to that. And then we'll bring it back, and I really would like to bring it back with more context around this as far as what are we going to be posting on the portal for these 5 incidents that we control for getting DHS. Because I think it would help a lot to know how much of the alarm system we can control ourselves.
And how much context. On those 5 cases, if we could actually see what the rule violations were and what will appear, what is appearing or on the, for those 5, right? What the violation is, what appears, that would give us a lot more insight into what are parents going to know, right? Yeah, we can do that regardless of DHS. Okay.
Any, Angela or Jay, any other suggestions on other suggestions you have?
No, I think I have my work list, so.
I think with this whole piece, it's important somewhere in here to assign it to DHS. Right, I mean, like, you know, when DHS determines that there's a substantiated blah, blah, blah,
Okay.
then this is what happens, to try to at least draw a little bit of a distinction between what they do and what we do.
Great, okay. All right, let's go ahead and do it. Let's start the team.
Wow.
Yeah, and we usually preview next month, so we want to talk briefly about. Oh, thank you.
Right, bring your sleeping bags. No, I'm just.
You feel like you typically preview?
Yeah. So go ahead, I'll start and you can fill in. So essentially,
October is our final meeting, and so we would be bringing forward the recommendations as we heard them. There's some follow-up components on two of them, this one and another one, I believe, to kind of finalize that recommendation. And so that is the hope, is that we're able to finalize a set of recommendations to move forward to the Early Learning Council for consideration. Anything to add?
I would, yeah, thank you. I think that's correct. And I would just add to that, that we will probably lean pretty heavily on that cumulative report summary to guide our time together. And we'll need to, in the agenda, allow time for continued, for, what's the right word, for coming to agreement on what the where there is outstanding information needed and then additional discussion needed, time to actually finalize what the group's recommendation is on this couple, this one and at least one other one.
And I think the other piece that would be helpful is if staff can sort of capture and summarize what are the design features that we have focused on most heavily. That wasn't our assignment, but what is staff taking away from all of these conversations about what needs to change in the design of the information on the portal? Because we've talked about that a lot.
Every meeting.
Every
single one.
Not that you have the answer to that, but at least put down what are the bullets of things that we know our technical staff is going to be working on.
Okay, all right. Anything else for the good of the order that I've missed? Okay, all right. Let's reflect on today's time together. What went well for you today? What worked well?
I think the small groups still work well.
Small group, okay? Good.
It's really fascinating to hear what the other groups, where there's agreement, and that's very helpful.
Cross-sector piece of the group.
Right.
And really helpful.
Great. Great.
The background materials, once again, I thought were a great guide.
I always like being able to ask a bunch of questions and the terminology and not understanding exactly how the words are used. It's really helpful to be able to throw a question out there and have very helpful answers from a variety of different folks. So,
Kara and Shannon, any feedback on what went well for you or suggestions for change?
I guess part of me wishes there was more parent voice too, in this. Yeah, I really appreciate the parents that do speak up in here and have said their piece. But again, I think that is one piece that we're missing a lot, is having more voices in that perspective area. Because we can only guess on what parents are going to think when they go onto the portal. But, you know, I work with parents all the time, and so do some of the providers. But, you know, I can only guess based off of conversations and things that I've had with parents and providers. So that's my 2 cents.
Point, Shannon, and I think a subsequent piece after this committee is done is to take out whatever the recommendations are and get some more feedback. Am I correct in that?
On the actual usability, on the pieces of like functionality of the portal.
Oh, that's what the.
So not on these policy questions, but on, once we have these questions around what information should be shared, then we're gonna need to engage parents around, because they're our primary audience, the primary users of the portal. So how should that, how can we make that more user friendly? How can we make that, all those kind of design things you guys are also been talking about, but that's really where we really want to get parent feedback on improving those aspects. That's also clearly.
Because I mean, I think I agree, and I'm sorry if I don't remember the parent's name that's there, that we sometimes as professionals in the early, we overthink things. And as a parent, from what I've worked with, going onto these portals, there's groups of parents that are going to be going on to that. There's some that are I'm going to be looking through everything. There's some that are just going to scan and look for this, that, and the other, and move on and get their list, and, so I know as a professional, as a mom, I would probably be one of those dig deeper types, because I'm in the system and I know it. But as a parent, you have many that are just going to go in, get their basic thing. They're not going to spend, that much time in it, and they're going to move on. So whatever we put in there has to be friendly to that, I guess.
Thank you, Shannon. Any other positives that you'd like to identify, or appreciations and suggestions for change as we approach our last meeting in October?
I think the expertise of all of you that are here, just the professional knowledge you have is incredibly helpful in understanding what is going into these policies and why. I'm really just honored to be able to be here and see the behind the scenes part of it.
Oh, we appreciate you being here, Stephanie. Your voice has obviously been a really important one, so thank you.
Bobby, were you going to jump in as well?
Yeah, I just wonder, it'd be great if everybody was here.
For the last meeting. So recruit.
Well, I don't know. If there's anything we could do to get everybody here, it'd be great.
Yeah. Great. Okay.
We'll do phoning.
All righty. Okay.
The governor can be here.
That's a great suggestion.
Mark. Yep. Never heard that.
If the governor's the one that suggested it.
Yeah, we'll wrap up with
What's the
her.
magic to it? Awesome. All right.
She'd be fascinated with these conversations.
Yes. All right, everyone. Thank you so much for your time and your thoughtful contribution to this conversation. We'll look forward to seeing you in October.
Thank you,
All right.
Heidi. Thank you very much. Great job. Oh, herding cats. Yeah. There are some conversations, you kind of feel like you're playing for here. Like Joe. You're like a